So imagine this. You're born with a name. You start a business using that name. You register a trademark for that name. And then someone who wasn't even born with that name becomes one of the most famous people on the planet, using a slightly different spelling of it, and then tries to take your trademark away. The audacity would never happen, right? Well, that's the story of Taylor versus Killer Queen LLC, decided by the High Court of Australia, and it's a good one. So the story starts with a Sydney-based fashion designer named Katy Jane Perry. In 2007, she starts a self-named clothing label called Katy Perry. Meanwhile, in the faraway land of America, Katherine Hudson has been performing under the stage name Katy Perry since 2002. By mid-2008, she was kissing girls and liking it, climbing every music chart on the planet. By late 2008, she was certified hot and cold. Hot on the charts, cold to anyone standing in her way. In July 2008, Katy the designer hears this song on the radio and thinks, "Oh cool, someone famous has my name." She buys the song on iTunes to support the pop star. On September 29, 2008, Katy applies to register Katy Perry as a trademark for clothing. That's class 25 for the trademark nerds playing along at home. That date, the priority date, becomes the hinge on which this entire case swings. Within months, Katy Perry's legal team come in like a dark horse, sending cease and desist letters, insisting to withdraw the application. Katy posts a YouTube video directly to the pop star, asking to be left alone to pursue her teenage dream of running a fashion label. The pop star's response? An email to her manager, calling the designer "stupid bitches" and "dumb bitch" with charming roar. Katy's mark gets registered in July 2009. The pop star's team actually withdraws their own clothing trademark application in Australia after being told it was too similar. You'd think that'd be the end of it, but no. This one is never really over. The pop star's companies starts playing with fire, spending the next decade selling Katy Perry branded clothing in Australia at concerts and stores, knowing full well about Katy's registered mark. The trial judge described this as a calculated disregard of the designer's rights. In 2019, Katy finally sues for infringement using litigation funding, because taking on a global pop star isn't exactly going to cost change from last Friday night's meal. The primary judge, Justice Markovic, finds in Katy's favor. Katy Perry Inc. unconditionally infringed her trademark. Additional damages were awarded because the infringement was flagrant. The cross-claim to cancel Katy's mark dismissed. The judge found that while the pop star had a reputation in music and entertainment before the priority date, that reputation didn't extend to clothing, and there was no evidence, not a skerrick, to use the judge's word, of any actual consumer confusion. But the full federal court saw it differently on appeal. They found the primary judge had unduly confined the pop star's reputation and ordered Katy's trademark canceled. Just like that, a decade of building a brand gone. Lying wide awake at night and unable to let this one go, Katy appeals to the High Court. And this is where we really start seeing fireworks, legally speaking. The court splits 3-2. Justices Jaggett, Stewart, and Gleeson form the majority. They find the full court got it wrong on multiple fronts. Justice Jaggett's reasoning is meticulous. The Katy Perry mark had a reputation in music and entertainment, sure, but not in clothing before the priority date, because not a single item of Katy Perry branded clothing had been sold in Australia by September 29, 2008. A general common practice of pop stars selling merch can't magically extend a mark's reputation to goods it hasn't actually been used on. And the absence of confusion over 10 years of both marks being in the market, that's not nothing. It's significant evidence. Justice Stewart goes further, invoking the concept of the assiduous infringer, a principle dating back decades in Australian trademark law. The idea is simple. You shouldn't be able to persistently infringe someone's mark and then use the confusion you created as grounds to cancel their registration. That would be, as one earlier judge put it, an extraordinary result. The appeal is allowed 3-2. Katy's trademark is restored. The matter goes back to the full court for remaining issues. Notably, the minority, Justices Gordon and Beach Jones, would have dismissed the appeal, finding the grounds for cancellation were made out. It was close. The moral of the story is that being a California girl, or any kind of global superstar, doesn't automatically entitle you to someone else's legitimately registered trademark. And if you spend knowingly infringing that mark, don't act all peacock proud when the High Court calls you an assiduous infringer in a published judgment. That's all for now. Thanks for watching, and as always, keep imagining.